We're live.
We're live. Well, good evening. This is Ian R. Crane. It's shortly after 5:30 on the evening of Friday, 14th of November 2018. Yep. And those of you who've been following my broadcast this week will know that I've been in the the Rolls building here, the commercial courts, challenging the iGas injunction, and I'm delighted to be joined this evening by my barrister. This is Paul Powlesland. So, Paul, this is rather unusual for a member of the legal profession to be talking with me. Well, certainly on this basis.
At least outside of court.
Yeah. Exactly. So, but thanks for joining me this evening. So, first of all, why are you here?
Why am I here?
Yeah, we're in the street.
Yeah. So obviously I've been making submissions on Ian's behalf for the last 3 days in the High Court. And obviously normally lawyers will just walk out of court and that's the end of their role. But as we'll hopefully see in the course of this live stream, the issue about injunctions and environmental protest is not one that can just be fought in the courts, because as we'll probably go into, the law is kind of against environmental protesters at the moment. And so I think it's really important to come outside and explain the wider political issues around these injunctions, and to try and explain what's going on with the legal process and how people can maybe start to challenge that.
Well, the title of this evening's broadcast is that this is not my first rodeo and it probably won't be my last, and I take no credit for that quote, because actually that was the opposition barrister who used that quote when he was trying to get the judge to award the court costs or their costs against me. But we'll come back to that issue. But obviously my regular viewers will know that I have challenged previous injunctions, and in fact have been up against iGas in the past, not least of course when we resisted the attempt by iGas to evict the camp at Barton Moss. But this was the injunction being sought by iGas to prevent any kind of effective protest at their 3 sites, 2 in Nottinghamshire at Misson Springs and Tinker Lane, and also at Ellesmere Port in Cheshire, where iGas don't actually have planning permission to go back to right now. But one of our core issues was the fact that what we are seeing with these injunctions is a raft of supra-parliamentary, which Paul refers to as quasi-legal legislation that's effectively not being established from any part of our parliamentary democracy, but is actually being established by the judges.
Yeah. I mean, maybe this is a good juncture just to explain to people. If you've been watching him for a while, you probably know about this already, but shall I give a very brief overview of the legal position? So, what we were doing in court wasn't really challenging the parts of the injunction that related to trespass on the actual fracking sites. But rather challenging the fracking company seeking to put an injunction over the public highway and to prevent forms of protest on the public highway. Now, I should say at the outset that what they were saying was, and what was accepted by the judge, was that those protests that were being prevented by the injunction were unlawful protests. So they were saying, well, act lawfully or we'll injunct you. But my submissions in court, and what I really want to reiterate here, is that even if protest is unlawful, there should be proper routes for people who seek to stop that protest, and that's a very good reason that we'll come on to. But in this case, there is already a criminal offence that stops the forms of protest that iGas didn't want, which is obstruction of the highway and or public nuisance. And so if people were obstructing the highway in protesting against fracking companies, that would be unlawful. And the police could arrest them for it, and they would be punished according to the punishment that we have all, through our democratic representative, decided is the correct punishment. But, and this is the key thing, that punishment is not enough for the fracking companies. They don't think it's enough. And of course, if you or I don't think that a punishment for a criminal offence is enough, then we'd have to go to Parliament, and we'd have to lobby our representatives and say, actually, for instance, for me, I would say the punishments for environmental crimes are not enough. People get off with companies get off with small fines for polluting rivers, or chopping down trees, or many, many things. I would actually be in favour of harsher criminalisation for breaching tree preservation orders, for instance. But if I want that, then I've got to go to Parliament and persuade our representatives to vote on it and say why I think the punishment should be increased. But the fracking companies don't seem to want to do that. Maybe because they realise they couldn't, and that actually Parliament would tell them no.
So they simply rock up here at the Rolls building, make an application, generally ex parte, in other words, claiming that it's in everyone's interest that they do it in secret, and basically get it rubber stamped.
Yeah, and so the way injunctions work is they work to enforce civil law. And normally with civil law, you can see, for instance, trespass is an obvious civil law right, but it gets ever more grey at the margin. So the civil law they were relying on here was public nuisance, for which they'd suffered particular damage on, i.e. people blocking the highway in front of their lorries. And so they then get a form of criminalisation, because if you breach an injunction, if you breach the injunction that's been made today, it's contempt of court, which is a very serious matter, and perhaps rightly so, where it's justified that an injunction is made. And it's probably good to look at what happens to people under the different systems if they do a certain act. So if someone sits on the road outside one of the fracking sites, if they're arrested by the police, then they can be convicted in the magistrate's court, and for obstruction of the highway, it's either a level 3 fine or 6 months imprisonment. I need to double check that.
It's not an imprisonable offence.
It's a level 3 fine.
So it's £1,000, maximum is £1,000 fine.
So, £1,000 fine. Thank you for putting that into layman's terms.
Okay.
So it's £1,000 fine. And also you'd only suffer criminal costs. So in the criminal courts, costs are not that much compared to civil courts. Usually a few £100s, it depends on your income. So, usually a few £100s, it depends on your income. So that's what would happen to you. Now, we've heard an actual quote from their QC as to why the fracking companies are not content with that. And he said, and I should state this very much to the outside, like, this is not necessarily verbatim, but in words to these effects, that going through the criminal law is not enough to pick people off individually, because they would just go to the magistrate's court, get a 50 quid fine, and be back the next morning. And that's why the criminal law is not sufficient for the fracking companies. Now, we'll go on later as to why society might choose to punish some offences like obstruction of the highway reasonably lightly. But the fact is, they have chosen that. And now, following this injunction that's been made today, if you sit on the highway outside one of the fracking sites and block a fracking vehicle, and the fracking companies take you to court for contempt of court for breaching the injunction, the maximum sentence is 2 years in prison. It's unlimited sequestration of assets, so they can take all your assets. And actually, almost more important than all of these things, according to a lot of protesters that I've spoken to, is the costs in civil injunctions are astronomically
unlimited.
Higher. Unlimited, but also in general astronomically higher than in criminal cases. So in the Sheffield tree protester cases, where I appeared for the protesters who were being pursued for contempt, the costs were between £10,000 and £15,000, which ordinary people just simply can't afford. And it means, I guess, if you don't have assets, then you can go ahead and they'll get that liability made against you and you can't satisfy it. But if you have a home or any kind of asset, you're risking losing your home by engaging in peaceful, non-violent direct action, which is, I think, wrong, and also I think it's deeply challenging to the rule of law.
I think that the vast majority of Middle England would be deeply disturbed if they actually understood what's really occurring here, which is that effectively it's, I think, accepted in British society that if something is so disturbing to the wider community, then ultimately they have the right to protest. But what we're seeing here is that, to use the legal term or the judge's term here, these are qualified rights. In other words, you have a right, but it is limited to something that is totally ineffectual, like standing on a corner or standing on a verge and waving a placard and banging a tambourine.
Yeah, so that was, again, it's another quote from the barrister appearing for the fracking companies over the last few days, where his version of protest that he was putting forward as legitimate was, as he termed it, fully lawful protest, where you walk down the Strand for the poll tax waving a placard, or you stand just to the side of the gates with a placard on the verge and banging a tambourine. But of course, we know that form of protest is actually rarely effective. And what I think was not said in the hearing, or not brought up enough in the hearing, is this issue of what kinds of protest are either justified or that people are, if not allowed to do, not overly punished for. Because the fracking companies kept coming back saying that, this is unlawful protest, and therefore we must get this injunction. But even where protest is unlawful, and I should say right here that I do not condone, encourage, incite, or in any way propose that people take unlawful action, but many people do. And crucially, it's been shown throughout the history of our society that people taking unlawful but peaceful direct action and protest is often a major route to social change that we regard as a positive thing. So today is the 100th anniversary of women voting for the first time. And that, in no small part, was got because of people committing acts that were unlawful, but which...
and in many cases, definitely not peaceful.
Yeah, well, not even peaceful, but were unlawful. And there are many examples throughout history. In fact, most forms of social change that have happened as a result of protest, there's been a thing of unlawful protest there. But what normally happens is, of course, we as a society often say that protest, even though it's useful, if it's unlawful, we must punish it. But we also usually don't punish it too harshly, because we recognise that although it's often inconveniencing and problematic for society, it can also be really useful for society as well. So the punishments are often quite light compared to other offences.
And what we're seeing, though, is a change, and it's a change over the last decade, because documents from the now defunct Association of Chief Police Officers and documents that are no longer current from the Crown Prosecution Service, these documents actually acknowledge that protest, by its definition, may well cause nuisance and disruption. Mm-hmm. But that does not of itself necessarily make it unlawful. Mm-hmm. But what we're seeing now with this raft of civil court injunctions is that nuisance and disruption is effectively now unlawful.
It's
outlawed.
Yeah. And it's always often unlawful, but the key question is, even where it's unlawful, it's what do we do about that? And action like obstruction of the highway, it's unlawful, but as a society, it's reasonably lightly punished, because we recognise that although it's going to be annoying and disruptive, and we do wish to have some form of punishment, I say we, I mean as a society we've decided to have some form of punishment for it, that punishment has by Parliament been decided to be light, comparatively, a fine.
Indeed.
Because we recognise that actually throughout history, many people who've done such offences have brought about useful social change. I'd submit that's one of the reasons why it's quite light, and why any attempt to, say, have a maximum prison sentence of 2 years for obstruction of the highway might be, or unlimited sequestration of assets, or tens of thousands of pounds of costs, probably wouldn't get through Parliament as it's currently constituted. And even quite serious disruptions, like the P&R, Preston New Road, where the truck servers were on there for I think 96 hours. They got initially a prison sentence, as you know, but they, on appeal, it was decided that they should have got a community order, because imprisoning people for environmental protest that's peaceful is generally not going to happen.
Well, and that was the Lord Chief Justice as well, Burnett, wasn't it? Where he stated that a prison sentence, and I quote, was manifestly excessive.
Exactly. And so, where the fracking companies consider they can't pick off protesters through the criminal law, and that our societally agreed punishments for these actions are not enough, we see them going to the commercial courts to get injunctions for effectively higher punishment for the same thing. And that in itself is bad, because it, as I say, undermines the rule of law. It can undermine a just society and equality under the law, because, to try and formulate this, the cost regime in the civil courts means that this remedy is not available to ordinary people.
Yeah.
Now, it's interesting, the fracking companies did not reveal what the cost of bringing these proceedings was.
Well, even under some duress from the judge to come up with a number, they were reluctant to offer a figure.
And despite me asking them at the start of the proceedings what their costs were, they didn't want to reveal them. I've estimated throughout at £50,000 to £100,000, and they haven't demurred from that. In reality, given it was a QC, a junior, 4 solicitors, and there's 4 boxes of files, and
at least,
exactly, all these kind of things, it may well be in excess of £100,000. The key point is that sort of level of costs is just not available to most people. Most people, including myself, as another barrister, couldn't afford that and bring an injunction. So if someone infringes our rights, like if someone sat on the road outside our house and blocked us going home, we'd have to just call the police and rely on the police to prosecute it and rely on the punishments that are given under the criminal law. But where you're wealthy, and wealthier than perhaps 95 or possibly 96, 7, 8% of the population, you have another aim. And you can go to the commercial courts, get an injunction, and therefore get greater punishments for things that affect you, even where those matters concern criminal offences, and even where they're committed in the public sphere, on the public highway.
Now, Paul, this injunction, like all the others bought by the fracking companies, was bought initially against persons unknown. Mm-hmm. And so when they went to court ex parte, in secret, got it rubber stamped, even though then it was announced to the wider community that they got this injunction, they were clearly still hoping that no one was going to challenge it and it would simply be rubber stamped. So it's only when somebody steps forward as either litigant in person or with legal representation to challenge it that they actually have to stop and think.
Yeah.
Now, over the last few days, you presented extremely well, I have to say. You presented some absolutely sound arguments, and you did get some
changes to the injunction.
I would say material changes. Yeah. Maybe not changes of substance in terms of the exclusion zones, etc., but nonetheless material changes to the original order.
Yeah.
And yet it is still considered that we lost.
Yeah. Yeah, I mean, the whole persons unknown issue really adds to this a lot. Normally in civil cases you have parties, so you'd have, if Ian has a dispute with someone over a contract, it would be Ian versus that person. But in these injunction cases, they're now often entirely made against persons unknown, which means everybody who is committing the act prohibited by the injunction. Now that gives rise to a number of difficulties, particularly that persons unknown, i.e. all of you out there, were not represented, or often not represented at these hearings. Now this injunction applies to everybody, everyone, me, you, everyone out there. And because it's made against, but it's not made in your name, it's made against the person's unknown name, oftentimes no one steps forward to challenge it. Now there is a duty on the other side in those cases to be particularly honest with the court and be particularly forthcoming and helpful with the court and to put the other side's arguments as best they can.
Oh, is that a flying pig?
I couldn't, how can I say this in a lawyerly way? Well, I can put it this way, is that at the last two hearings, well, the first ex parte hearing in the current case, the very first hearing, it was just the fracking company's barrister, and the last hearing was both the fracking company's barrister and you weren't legally represented. And following the hearing today, we've got 3 changes to the injunction which weren't made at the previous hearings. And that suggests that if you have a barrister and you are legally represented, there's a reasonable chance that you will get changed the order. Even if you don't get the whole thing knocked out, it tightens up the order, it makes it better drafted. There are a number of errors with the order, frankly, that got through until I sort of spotted them and picked them up in the last few days.
Absolutely.
And in my submission to the judge, I said this is fundamentally unjust that these orders are being made against persons unknown when persons unknown is not represented. And that was almost added to when later on the judge said, well, this is, when I asked the judge for help with saying how this order could be tightened up, he said, it's an adversarial system, I can't enter the arena. To which I replied, who's acting for persons unknown then? And the answer seemed to be, nobody.
Exactly.
No one's acting for persons unknown. And again, this goes back to the idea of criminal law versus injunctions. When you've got the criminal law, you've got Parliament at least looking out for the interests of everybody. They're drafting it and weighing up everyone's interests and deciding, is this well drafted? Does this make sense? Does this ban things we don't want to ban? Is it fair? Is it just?
And then it has to go through the Lords.
It has to go through everyone. It has to go through parliamentary draftsmen who draft it properly.
Yeah.
Here, we're getting these effectively quasi-criminal laws made, often with no representations on the other side. And I want to go further on this as well, because we saw this with costs today. And I also want to make a point here as well to say thank you to Ian, actually, for standing forward and challenging this injunction effectively on behalf of everyone. And he was actually thanked by the judge in court for doing that. And I also thank you as well. It's a public-spirited thing to do. And had you not done it, I believe an injunction would have been made that was different and that would have banned things that shouldn't have been banned, as recognised by the judge's findings.
And at the very least, if it hadn't have been for you, I think I might have been looking at a rather bigger potential bill.
Yeah, so this is the other thing about, so we did actually get some changes to the injunction, and not only did Ian not recover the costs of instructing me, but he was actually forced to pay some of the fracking company's costs for standing forward and on behalf of everyone checking that this injunction is properly made and that it contains the terms it should. And I say we got some material changes. As a result of the changes we received, people can protest on the verges outside fracking sites, which the word verges wasn't included in the order before. So there was a good chance that certain protests on those verges would have been banned. Similarly, the word encouragement, encouraging others to do things, was changed to incitement. So
which is very significant.
Doesn't sound like a big change, but incitement has a much more legal meaning. And encouragement is a very wide word indeed, such that actually some of your previous video streams could have been included in that. So as a result, would have been, yeah. Because they are effectively encouraging people to commit these acts of direct action. So, and that would be very serious for you. You know, you could end up in jail for that. And as a result of stepping forward, we got that changed. And not only do we not recover our costs, you've now got a cost order for that. But the public,
but to put it in perspective, the actual costs scenario was very interesting because the iGas legal team were actually very reluctant to provide a number today. And what they were looking for the judge to agree to was obviously significant costs based on them actually preparing a cost schedule.
Yeah.
And the judge was actually quite, I think, a bit frustrated by the fact that they hadn't got a cost schedule and they weren't ready to make a claim for costs. So he forced them to come up with a number. And they were alluding to, they didn't mention a specific number, but it was very clear that they were alluding to a significant five-figure sum. Yeah. And the judge actually made it pretty clear that he wasn't minded to go to that kind of level. And through some exchanges, I mean, we got it down. So my total costs for this, and this includes Paul's expenses.
No, it's fees.
His fees. But the judge the judge ruled that my total costs for this are £3,000. And, the judge acknowledged that if it hadn't have been for having a litigant in person, then obviously the outcome would have been very different. And let me tell you that the outcome would have been very different if I was just standing as litigant in person and didn't have legal representation. Yeah. So although up until now I have resisted having legal representation because I've always felt that unfortunately the members of the legal profession were reluctant to actually push the system where it needed to be pushed. And although obviously, Paul perhaps can't go certain places that I might like him to, I have to say that I have absolutely no qualms about the way in which you conducted the case. Absolutely brilliant.
Thank you. I mean, I although I may not be able to make as many submissions as you could as a litigant in person, I did make submissions that I think lawyers don't often.
Indeed.
Mentioning the broader issues around the rule of law, parallel criminalisation, and the access of law by the wealthy and not those who don't have that money. And those, I think, were surprising to the other lawyers. I don't think they've necessarily been used to submissions like that. And also placing it in the broader context as well of these protesters haven't come out of a blue sky. We're looking at very serious environmental crises, whether it's climate change or soil crises or all the environmental problems with fracking. There's so many at the moment. And actually I was very proud to be able to put those broader issues in court. I just want to go back to the issue around costs very briefly because it leads on to something else that I want to talk about, which is this. So Ian didn't recover the costs of me attending and had to pay some costs. And I submit that actually that is obviously completely, I think, wrong. But also I don't just want to sort of necessarily be us sort of standing here and moaning about the law and moaning about things. I want to present some solutions. And I believe there are a number of very accessible solutions to some of the problems that we've outlined here today. Mm-hmm. And I'd quite like to put those forward, actually, so it's not just negative. Yeah.
Go for it.
So the cost thing and the person's unknown thing, I think there's a very simple solution to this, and one that in my mind and in my opinion is pretty unanswerable, actually. If you are going to seek an injunction against persons unknown, you must, as part of the costs of seeking that injunction, pay for an independent lawyer and barrister to represent the interests of persons unknown in court.
I think that's an exceptional recommendation. And maybe we have to actually initiate a judicial review to actually get this put forward, because otherwise what this trend that we're seeing isn't going to stop with fracking. You know, whatever the hypothetical situation, and I touched on this in my live stream this morning, but whatever the hypothetical situation, in the future, whatever an industry wants to do, provided it has in theory got permission from Parliament and all of the appropriate regulatory authorities, providing it's got permission to do whatever it is that we're discussing here. I mean, you know, nuclear waste may be one particular issue, for example, but then they can simply rock up to the courts, get an injunction, and there's no opposition.
Often no opposition, or you know, where opposition is given, like it was today, because you public spirited, you actually you're having to pay thousands of pounds for your public spirited action of challenging the injunction on behalf of everyone, and to me that's ludicrous. And even on the principles of the legal system, even on their own principles, it's such a basic principle that you should be that there should be equal representations in court proceedings. You have to be able to appear. And the fact is that normally works by notifying parties and saying that you have a court case on, and you should attend. If you don't attend, you don't make representations. That's fine. But the point is that today an injunction was made against persons unknown. That's everybody, everyone listening to this, everyone out there, and those interests in persons unknown were not represented. I mean, I did my best on behalf of Mr. Crane to do that, but they are not represented. And I think that's a very simple thing. And given that these injunctions often cost 50 to 100, more than that, thousands of pounds, actually putting in even just a tenth of that amount that they have paid their own lawyers to actually represent the interests of persons unknown, I submit would be not just reasonable, but actually it's a necessity. And I think people should start making noise to campaign for this. That should be a basic requirement. And I want to finish one more. Another thought has occurred to me. In that court, we were ranged against 4 lawyers, 4 solicitors from the fracking companies, a QC and his junior. And if Mr. Crane had not stepped forward and public spiritedly decided to challenge the injunction, there would be no one on the other side. So why not take the cost of just 1 or 2 of those lawyers that were ranged from the fracking companies, put them on the other side, and at least have the interests of people at large represented? Because ultimately, if the fracking companies are right and they deserve this injunction and it's fully legally okay, then of course they're not going to mind having the interests of the other side vigorously put forward by an independent lawyer. And I would submit they clearly have the resources to do that, because they had so many lawyers in court today. They've got the resources, so we must campaign, I think, to make that happen.
I think you're right. And I think, just to put it in perspective, when pushed, what emerged, and they were pushed by the judge, Alan McLean's daily fee was £7,500, and that was just the QC. So we had £7,500 for the QC, he had a junior, and then £300 an hour, wasn't it, I think, for the solicitors. So, you know, we're talking massive costs that iGas investors had to stump up to get this injunction. Mm-hmm. And of course, as far as iGas are concerned, it would have been money well spent if they had not had any opposition. Yeah. And of course, there were some changes, some significant changes. And well, it wasn't my first rodeo. It certainly wasn't yours, and I suspect it's probably not our last.
It's not. I previously represented Sheffield Tube testing injunction cases, and also those testing HS2. I imagine there are many others. I will keep going, I guess, and so will you. And I hope I don't have to keep representing people in these cases, actually, because in many ways it shouldn't be like this, but I suspect it will be for a while. And also, if necessary, representing people who, if people are brought contempt proceedings against under this injunction, representing them as well, representing their interests, because actually, I still, although the wording was tightened up, I still think there are potentially things that are otherwise lawful that are banned under this injunction. I want to say as well, another proposal for change, and again quite an easy one, is that we should, this may have to come from Parliament now, because the judges are showing no sign of giving up their willingness to make injunctions where there's also criminal law, that we should not allow civil injunctions to be brought where there is already an existing criminal sanction.
And this is something else we have to perhaps pick up with the elected representatives.
Yeah.
Because it's effectively saying, well, what's your point? What's the point of an elected representative? You know, when we've got a critically ruled by judges.
Yeah. So that's another reasonably simple change I would make. Oh, and another one actually. This wasn't actually dealt with by the judge.
You want to call him back?
Well, I should have said actually in his judgment it wasn't dealt with. The point I made that that in the order, I made a submission in court that if this is to be made in circumstances where there is a criminal law already, that in the order it should be recorded that any cost in contempt proceedings should be the same as in criminal.
But we have an opportunity to float that back across the judge, because he said any changes you want, so you can still put that in your email.
Well, we'll see. I mean, I imagine he'll probably reject that submission, but it's what will be described in legal circles as novel. But I think it's also important for it to be rejected, so then we can say, well, there's a point to campaign on here.
Absolutely.
Why can't we include in these orders? If your intention is just to get this injunction to and not just to use it as a means of putting extra financial pressure and costs on protesters that wouldn't be warranted under criminal law. If that's not your intention, which I'm sure it's not the intention of the fracking company to do that, not one little bit, but if it's not your intention, then you wouldn't mind having it written in the order that the costs are to be the same, equivalent as in criminal proceedings. I just don't see how it's justified that if a case is brought under the criminal law for obstruction of the highway, you get a few £100s of costs, and if it's brought for contempt of court under civil proceedings, you get tens of thousands of pounds of cost potentially. I don't get why that's justified. So those are the three changes that I've found. I'm sure there are many others, but the three that occur to me: a lawyer to represent the interests of persons unknown, no injunctions to be granted in respect to behaviour that's otherwise already criminal, and if that is to be granted, then any costs in contempt proceedings brought under it should be equivalent to those in criminal proceedings.
It's a start point for sure.
It's good to propose things rather than just sort of, it's been. I've been in court a lot over many years, but I found the last few days very interesting to see how the system is currently operating in some places, and I found it very fascinating.
Well,
as I say, it's good as well as to point out the difficulties of the current system, to give reasonably simple solutions that could be adopted to try and at least address some of the issues.
Well, I've got to say, and I don't think I've said this ever before, but it's been an absolute pleasure to work with Paul as a member of the legal profession. And like I said, you absolutely took it to a whole new level for me. And certainly as litigant in person, I couldn't have presented to the degree and the depth that you did over the last few days. So thanks for that.
Thank you.
And I'm pretty sure we'll have the opportunity to do it again at some point.
Not for a bit.
Call it a hunt. Anyway, I should be heading back to Mission Springs Protection Camp, and we have an open day there tomorrow. And so if anybody's in the area and you want to chew the cud on what's occurred over the last few days and discuss some of the finer detail, and also discuss maybe some of the ways in which we can take forward some of Paul's recommendations for moving forward on this. So Paul, it's as I say, been an absolute pleasure. Thanks for all your help. And if anybody is in a similar situation, challenging an injunction, it's Paul Powlesland, and I'll put his contact details. No, but it's Paul. If you need Paul, you'll find him. That's for sure.
Yeah.
So anyway, an absolute fantastic end to the week in many respects. Not necessarily the result that we hoped, but some very, very significant changes to the order that there's no question iGas would have preferred not to be either removing or including. And we keep chipping away. Eventually, we will find a judge that has a conscience, because one of the comments made by Judge Barker in his summing up today was that the unconventional hydrocarbons industry is a matter of national importance. And as I said this morning, unfortunately, when we come into the commercial courts, we know that commerce trumps human health and well-being. But we just got to keep moving forward with this and eventually we'll make the breakthrough, just like the suffragettes did 100 years ago.
That one's just to try and get the last word. I do want to say that even though the actual result of the injunction may not have been what we wanted to, I think there was a real importance in putting a lot of the arguments that we did down.
Absolutely.
And especially these wider issues around both the environment and environmental protection, but also civil liberties, the rule of law and all those kind of things. And I sort of grimaced earlier because when Ian was trying to plug me a little bit, because obviously it's very nice and I was thinking, actually, what are the rules on advertising at the bar? I'm not sure I'm allowed to advertise. I was thinking, but actually, what I want to say is as well that I am doing this partially because I really love the process of what we went through the last few days. I found it very, very joyful to make my submissions and be an advocate in the way that I did, but also because I care about the rule of law and civil liberties. Most pressingly for me, though, is that I care deeply about the protection of the natural world, and that is my overriding joy and mission in life, and what I most want to express through my work. So I don't know if I'll always be able to act for anyone there's so much work that he's doing to use the law to protect the natural world, but as much as I can, that's what I want to do. So if you hear any cases that need that, then I will always try and do my best to represent them, because that's what I want to do. So I think, my name, if you Google it, it should get my chambers, and I'll try and do my best to do that, because that is the key mission for our society for me over the next coming years and decades, is how we protect the natural world, and if we don't, then it will be disastrous for us all.
Well, as I've said many times, if we don't actually step up, then we will be condemning future generations to lives of currently unimaginable abject misery. So, we have this shared responsibility. So it's time to make a contribution. And you've certainly made yours, Paul. Thanks a lot, my friend.
Bye-bye.
Okay, that's it from us here by the statue of John Wilkes, the champion of English freedom. Well, if we're not careful, it'll be eroded. I wonder what John Wilkes would think if he had been sitting in on the proceedings over the last few days. So thanks a lot. I will be back with a live stream on Monday morning at 8:30. Meanwhile, say if you're anywhere near the Missing Springs Protection Camp, please feel free to drop in tomorrow afternoon, or any time, of course. And have a great weekend. See you on Monday morning. Bye. Thanks, Paul.